You are watching Morning Musings with Reinhard von Hennings, chairman and founder of Bridge House Law in Charlotte, North Carolina.
How high are GDPR fines? Hello, this is Reinhard von Hennings. Recently, we learned the biggest fine ever. Meta, the US tech giant formerly known as Facebook, had been issued a record-breaking fine of 1.2 billion euros for failing to comply with the European Union's data privacy regulation. The Irish Data Protection Commission, on the eve of the 5th anniversary of the enforcement of the General Data Protection Regulation, known as GDPR, on May 25th, announced that Meta violated GDPR by transferring large amounts of personal data belonging to European Facebook users to the United States without adequate protection against US data surveillance practices. This fine is notable, not only that it happened on the eve of the 5th year of the enforcement date of GDPR, but also it is the largest ever fine imposed under the GDPR privacy laws. 1.2 billion euros, which is 1.4 or so billion US dollars. It is a lot of money. Over the past 2 years, Irish regulators had previously fined Meta's platforms, including Facebook, Instagram, and WhatsApp, in various amounts, from 225 million up to 405 million. Additionally, it's a different company, but a large fine was implemented by Luxembourg against Amazon in an amount of 746 million. Before the GDPR really became effective, there had been a couple of lower cases. 2019, at that time it was Facebook, not Meta, had been held liable for violating European data protection rules by the French authority. The National Commission on Information and Liberty, CNIL, fined Facebook in 2019 for 50 million for a lack of transparency and for lack of consent regarding the date of user data. UK in 2019 did the same. At that time, UK was still part of the European Union. And the fine at that time by the Information Commissioner's Office, ICO, in the United Kingdom was just £500,000. Also note that there was an involvement of Facebook in the Cambridge Analytica scandal, but all of this have been adjudicated prior to GDPR coming into effect. So while those fines were issued prior, let's talk about the current fine structure. Fines under GDPR can be significantly higher because it can reach up to 4% of the company's global turnover, or 200 million, whichever is higher. So this is why the numbers went up. But what's the story behind? What happened? Meta uses a standard contractual clauses known as SCCs, which is a legal instrument used to transfer data to the United States. This SCC was deemed insufficient by the Irish privacy watchdog. The decision was influenced by a landmark ruling by the European Court of Justice, ECJ, in 2020, which invalidated the EU-US data flow agreement, which at that time was known as Data Privacy Shield, due to concerns over, and here is the story, the US practice of data surveillance. So this US surveillance practice was considered to be the problem, and regardless of what happened at that time in 2020, Facebook, now Meta, continued the practice. So the court tightened in that ruling the requirements for the use of SCCs. While the negotiations for a new data flow agreement between the European Union and the US are still ongoing, Meta has now until October 12, 2023, to stop relying on SCCs for data transfer, meaning they need to do SCCs plus something more. The failure to find some alternative arrangement could potentially lead to the suspension of Facebook services, Instagram services in Europe. And Meta has also until November 12th to either delete or to relocate personal data out of European Facebook users which have been stored in the United States back or deleted, whatever they did since the year 2020. It is, of course, contingent upon reaching a new European Union-US agreement. Where this stands, it is speculation. Meta is, what we heard, up to challenge the decision and want to go out in full steam to file appeals. However, the company also has expressed concerns over the decision and the impact on other companies which are involved in the European Union to the United States data transfer. So whatever the arguments are for Meta, they call it, of course, unflawed and unjustified, is at the end a decision of future courts or future data protection commissions or agencies. The Irish Data Protection Agency at this time disagreed. They disagreed that the finance and measures were wrong, but they were compelled by the European Data Protection Board to enforce challenges, as Germany, France, Spain, Austria, and other companies had approached and said something needs to happen here. The Irish situation is in a way different, as many international companies have their headquarters in Ireland. Whatever the future will bring with regard to an agreement between the United States and Europe, whatever any future appeal from Meta will bring with regard to the implementation, the fact that Meta got this right to implement means at least good news for now and for the users. There is no immediate disruption of Facebook services in Europe. Well, is it really good news when your data are being shared in a way which is no longer secure? That's a different question. So my question to you right now is, as a company owner, as an entrepreneur, how are you implementing GDPR rules? Are you aware that even as a US company or a Canadian company or any other non-European company, you may still be subject to GDPR? Here's why and when. As a foreign company, the US company, for example, must follow GDPR if it meets certain criteria outlined in the regulation. GDPR applies to companies outside of the European Union if they possess data of individuals from within the European Union while offering goods or services to them, or if they plainly monitor the behaviors of individuals. So as a best practice, and in practical terms, any foreign company would need to comply with GDPR if it either offers services to them, targets member states, target markets in member states, targets individuals in the European Union, regardless whether payment is involved, regardless what's really happening, as long as they're being targeted, it means that GDPR applies. So it's e-commerce, it is any online services available for European Union users. So back to you. Is your website with maybe any forms accessible to European users? Then you may be subject to GDPR. And the second part is monitoring individuals' behavior. If the company tracks or monitors behaviors, think cookies, or similar tracking technologies, this means that GDPR is applicable as well. So when a foreign company fails to comply with GDPR and processes data outside of the GDPR rights, they could be subject to a fine. So while US companies need to overthink and change potentially their behavior, seeking legal advice early on is always the best way to avoid specific fines and to ensure compliance with the specific requirements. So my last question for you today is your company GDPR compliant?
Thank you for joining us today. If you would like more information about British House Law, please visit our website at bridgehouse.law. Before you go, make sure to like this video and subscribe to the channel for more up-to-date content. Bridge House Law, business-minded, client-focused.
Whether you're a private citizen, an international business leader, or simply someone eager to stay on top of the latest news, this book is a great way to get caught up on the most recent developments in the worlds of international business, tax, politics, and social affairs. Go to morningmusings.com and order your copy today.